Hello and welcome to etbfsi.com. My name is Amol Dethe and I'm in conversation with L Viswanathan from Cyril Amarchand Mangaldas. Sir, welcome on the show.
Thank you.
It's been almost or more than 2-3 years now since the IBC came into the picture. Bankers and specifically the financial institutions are very happy because now the creditor is, can drag the debtor into the NCLTs and perhaps recover the most. But looking at the resolution, it's still very low compared to what we had expected. What is your reading about it?
I think it's a success story. I think it's one of the best reforms we've ever had in a while, which has had maximum impact.
Right.
I think the success of the bankruptcy law lies more in its use as a threat than its actual execution. So I'm quite happy if not many cases get, come to the bankruptcy court, because it means that they are resolved even before they enter the bankruptcy court. I see this happen on a day-to-day basis with debtors coming in, settling with the banks even before it is taken to the bankruptcy court. So I think the law has definitely served its purpose as in a very good deterrent. And I think the implementation of the law has had many success stories. Of course, any law which is new will take its time to settle down.
Right.
Precedents will have to develop, jurisprudence will have to develop. Compared to, more established markets like, UK or US, which have taken, 40-50 years to develop.
Right.
The amount of jurisprudence Indian courts have developed in the last 3 years is phenomenal, and something which all of us should be proud of. So I think it's a great step, and I think it is producing results.
Right. So obviously we have seen the results. There are obviously less complaints than the appreciation, in fact. But looking at the bench size, looking at the number of cases that's rising, what do you think? What kind of changes do you see, and what kind of changes do you think are required right now, to reach to a next level?
I think we need, obviously the infrastructure needs to be improved. There is always scope to it, but I think the government is very conscious and receptive of that. I think in the last 6 months, they have increased the size of NCLTs. They added approximately 30 new members, and they are all, at it, disposing cases on a day-to-day basis. So I think this is one law where government has been very responsive to the needs of the ground. I think they're going to look at setting up, benches of NCLT as well, so that there is no bottleneck in terms of the appellate court. Even in the Supreme Court, you have 2 or 3 benches of the Supreme Court which now deal with cases which come from the bankruptcy court. So on the whole, infrastructure is required to be improved, and I think the government is sort of conscious of that. It's a new law, and I don't think so we've had this much infrastructure being created for a specific law in any other legislation in the past. So I think it's laudable, but obviously the demand supply gap is quite a bit, so more work is required, and I'm only expecting that the gap will be filled.
Okay, but looking at now distressed assets, do you think the bankers are actually, or the financial institutions, those who are going to NCLTs, are actually getting what they had expected, or they're taking more haircuts?
I think they are, the once you go into NCLT, then it's a market price discovery. So, you will have to accept what the market gives. I mean, when you do a process which is either bilateral or outside NCLT, there's no measure really to test whether is it a sustainable solution. On paper, you may have got a better recovery in earlier schemes of the RBI, be it EDR, SDR, S4As, etc. But there is no measure to test whether that was a sustainable recovery. The advantage with the NCLT process is you're going through a public bid, so whatever you're getting is the best outcome. So at least you have the satisfaction that you're getting the best outcome possible. So I don't think so we can have sort of any regrets about that process.
Okay.
The rest would have been theoretical to say that I would have got more if I had done something else. So there's no better proof than going out to the market and seeing what's the best available option and taking that.
Right, because there is always a debate on the valuations, whether this value is the right value or it's absolutely the cheap value, and that is why in fact most of the foreign companies are vulture funds, to be very precise, are entering in India and buying the distressed assets.
Absolutely. And if you see wherever strategic investors are at play, the funds will probably step back because the strategics have a greater need for these assets. They will put in. But where there is no strategic player, then you see the funds coming in and trying to get the assets at the best possible price. But at the end of the day, it's a marketplace.
Right.
We can't sort of be we can't complain about the outcome of a market-driven process. As opposed to the legacy of not being able to even sell, not being able to even enforce your security over 5-10 year period. So a quick resolution will free up the capital and it will enable sort of recycling of capital, as we have seen in some of the initial sort of success stories. And I think it will lead to better credit discipline. I think there are lessons from these cases as well. Hopefully, it'll lead to better appraisals, better credit discipline, better documentation. So on the overall, a more positive credit environment, is again an acceptable outcome for the system.
Right. But since you're dealing with this, your legal firm is one of the important one, because you're dealing with many cases. What is your biggest learning in this in specifically IBC and NCLT related cases? Because bankers really learned this lesson that they should not lend to anybody and everybody. That is the lesson that the bankers told us. They learned. And if you look at the debtors, those were genuine debtors. They also realized that okay, we cannot make the same mistakes at all right now. And in fact, that is also one of the reason that the credit crunch took place in the market, because bankers are reluctant to lend to the new players, and they are going through the trust deficit, which impact we can see in the market in demand and consumption side. So what is your lesson that you learned specifically, because you are serving to creditors as well and you are serving to debtors as well?
I think lesson from me personally is that however sophisticated the law is, right, in India, at the end of the day, it is going to be implemented by common people everywhere. So I think the ability to drive home the purpose of the sophisticated law to all the stakeholders to get their buy-in, I think that's the biggest learning from my perspective. I think some of the initial cases were difficult, but I think those were the ones which made it a success too. For every member of the NCLT to accept a new and modern law, which is very creditor friendly, and we moved away from debtor in possession to creditor in possession, took a while. And I think the support which the law received from NCLT, the Appellate Tribunal and the Supreme Court was phenomenal. And I think that is really the biggest contribution, biggest learning, that yes, at the end of the day, if you are able to convince the stakeholders of the purpose of the law, from the point of view of the creditors, it gives them a quick, reasonably quick solution. From the point of view of the debtors, it gives them certainty and, easy exit or a clean exit, absent, right, those exceptional cases, which is also a good outcome. So I think helping people see the purpose of the law would really help in achieving the objectives. That's the biggest learning for us.
Okay, great, Viswanath. Thank you so much for sharing those insights with us.
Thank you
so much.
Thank you.
Bye. And thank you so much for watching etbfsi.com.